Welcome to another excellent panel in the Federalist Society's Executive Branch Review Conference. This panel is titled Environmental Law and the Constitution, Exceeding the Limits. There's maybe supposed to be a question mark after the end of the title, but I'll leave it to Mr. Mergen here to dispute that as we go on. My name is Stephanie Maloney. I am Chief of Staff and Associate Chief Counsel at the U.S. Chamber Litigation Center, and I'm also a member of the Federalist Society's practice group for environmental law and property rights, so very happy to be with you all today. That practice group is sponsoring today's breakout panel, and many thanks to members of the practice group who helped to plan today's program. It's my pleasure to introduce today's panel, and save for Matt, it feels a little like an ENRD alumni reunion, so I'm very happy to be a part of it. Of course, Matt has worked on enough WOTUS litigation to be considered an honorary member of the division, so we're happy to have him too. Litigation over WOTUS has seemed one of the constants in environmental law over the decades. But in his Sacket v. EPA concurrence, Justice Thomas suggested that this, and quote, many environmental regulatory schemes appear to push the limits of the Supreme Court's environmental and, the Supreme Court's constitutional jurisprudence. What exactly does this mean for federal environmental law as currently implemented and enforced? Is it, dare we say, all unconstitutional? To kickstart this debate, I'm delighted to introduce our moderator, Corinne Snow. Corinne is counsel at Vinson & Elkins and former counsel and chief of staff in the Environment and Natural Resources Division of the Department of Justice. In that role, she helped manage the division's civil and criminal litigation arising under more than 150 environmental and natural resources laws, although I'm sure none of the unconstitutional ones. She also helped to manage the division's more than 400 lawyers. So with that experience, she's certainly well qualified to moderate today's discussion. So I'll turn things over to Corinne to introduce our panel. Thank you.
Thanks, Stephanie. So as Stephanie said, we don't have a constitution that has a general regulatory clause in it, but we have federal statutes that govern things like our air, our water, critters, that don't necessarily respect state boundaries. So how do the agencies like EPA, the Department of Interior, who are tasked with managing those resources, deal with those issues, and are they respecting the constitutional boundaries between them? So I'm very pleased to get to moderate this panel, who is very well qualified to discuss these issues. As Stephanie said, two of the members are former colleagues and men who I consider mentors, and the third one, I've got to enjoy reading his briefing and writing and very much admired it as well. So we'll start from the end with Matthew Kuhn, who is the Solicitor General of the state of Kentucky, where he oversees all of the appeals of their civil and criminal litigation. Before that, he was the Chief Litigation Counsel to the Governor of the state of Kentucky. He formerly practiced at Jones Day and was a law clerk to Judge Grunder before that. So very, very pleased to have him here. And he is, as Stephanie said, leading the charge on some of the Waters of the United States litigation going on right now. Sitting next to me is Eric Grant, who is currently a partner at Hicks Thomas. Before that, he served as the Deputy Assistant Attorney General for the Environment Division, overseeing all of the appellate litigation there. He saw a number of the high-profile pipeline disputes while he was there, including ones that went to the Supreme Court, like the Atlantic Coast Pipeline. He was involved in the Keystone XL litigation, the Juliana climate change kids litigation, cases that spanned from the district court all the way up through the Court of Appeals and Supreme Court. He is a former law clerk to Judge Edith Jones on the Fifth Circuit, Justice Thomas, and was the last clerk to Chief Justice Warren Burger, which I invite you to ask him about after this panel. And then Professor Andrew Mergen is now the director of the Emmett Environmental Law Center at Harvard Law School. Before that, he spent his entire career at the Environment Division, starting as a honor grad after he graduated and working all the way up to being the chief of the Appellate Division. And here at the Federalist Society, we are all about a robust debate, not fighting straw man versions of the argument on the other side. And I will say that Andy is about the furthest thing you could have from a straw man. I can't think of any major environmental or natural resource issue over the last couple of decades that he has either not been involved with or thought really deeply about. So we are really lucky to have him here with us today. And I'll also say that while he certainly does not always agree with us on everything, I think every conversation that we had with him about the issues while we were there, we all came out better for having heard his views on it. And so I hope you all do today as well. And before I turn it over to Eric to start, just to give you a breakdown of what we're going to do. First, each of our panelists will talk for about 8 to 10 minutes and give some opening remarks. Then I'll give them the opportunity to respond to each other's remarks, ask a couple questions, and then we will open the floor up to questions from all of you. So please be thinking about what you want to ask, and I'll let you know a little bit before we're going to start so everyone can start lining up. Eric?
Thank you, Corinne, for that kind introduction, and I thank the Federalist Society for inviting me to participate in this august conference. It's a pleasure to share the stage with my former colleague, Professor Mergen, and with Solicitor General Kuhn. Both Stephanie and Corinne mentioned Justice Thomas's concurring opinion in last term's Sacket v. EPA, including the suggestion that many environmental regulatory schemes appear to push even the limits of the Supreme Court's Commerce Clause jurisprudence. And so Sacket is a good place for us to start. That case began in 2007 when Michael and Chantel Sackett, who owned a 2/3 acre residential lot near Priest Lake, Idaho, began preparations to build a house on that lot. But in the words of the administrative compliance order issued by EPA, the Sacketts discharged fill material into wetlands at the site. Now that's EPA speak for filling in part of their lot with dirt and rock. And because in EPA's view that 1/2 acre constituted jurisdictional wetlands, the filling violated the Federal Water Pollution Control Act, usually called the Clean Water Act, or CWA. So, being good Americans, the Sacketts sued EPA to challenge the agency's application of the act to their property. And it took 5 years for the case to reach the Supreme Court solely on the jurisdictional question whether that administrative compliance order issued by EPA was, quote, final agency action, unquote, subject to judicial review under the Administrative Procedure Act. And the court ruled unanimously that it was. It took another 10 years for the case to reach the Supreme Court on the merits, the question whether the Sackett's residential lot fell within what the court called the outer boundaries of the Clean Water Act's geographical reach. And in the interest of full disclosure, I must confess that I represented EPA when the case was most recently pending in the Ninth Circuit. But I secretly hoped the Sacketts would win. The geographical reach of the Clean Water Act is a question of statutory construction, and Section 404 of the statute prohibits the discharge of dredged or fill material into the navigable waters without a permit from the U.S. Army Corps of Engineers, which the Sacketts concededly lacked. Paragraph 7 of Section 502 of the statute in turn tells us that the term navigable waters means the waters of the United States, including the territorial seas. And the term waters of the United States, or WOTUS for the cognoscenti, is not further defined. If you're like me, you might conclude that this all boils down to federal waters are waters that are federal. But this is a good place to return to Justice Thomas's concurring opinion. It argues, convincingly in my view, that courts and Congress have long used the term navigable water navigable water of the United States, and the waters of the United States interchangeably to signify those waters to which traditional channels of commerce authority extended under the Commerce Clause in Article 1, Section 8 of the Constitution. And that argument relies on great 19th century authorities like Chief Justice Marshall's opinion in Gibbons v. Ogden in 1824, Justice Stephen Field's opinion in a case named after the steamship the Daniel Ball in 1871, and the Rivers and Harbors Act of 1899. Thus wrote Justice Thomas, on the eve of the CWA's enactment, that was 1972, the term navigable waters meant those waters that are, were, or could be used as highways of interstate or foreign commerce. And in the 1974 regulation establishing the first Section 404 permitting program, the Corps of Engineers interpreted the term waters of the United States to establish jurisdiction over traditional navigable waters as determined by the expanded Daniel Ball test, noting also that the term is limited by Congress's navigation authority. And so we reach the bottom line for Justice Thomas. It is vital that we ask the right question in determining what constitutes waters of the United States, whether the water is within Congress's traditional authority over the channels of interstate commerce. And here, no elaborate analysis is required to know that the Sackett's land is not water, much less a water of the United States. And I would add, even if that land is in some attenuated sense wet, a wetland. And now here's where Justice Thomas, as he often does, delves into the deeper questions. What happened to the CWA is indicative of a deeper problem with the court's Commerce Clause jurisprudence. As he has been doing for literally 3 decades, the justice again articulates his view that the court's Commerce Clause jurisprudence has significantly departed from the original meaning of the Constitution. And by departing from this limited meaning, the court's cases have licensed federal regulatory schemes that would have been unthinkable to the framers and ratifiers of the Constitution. And here's where environmental law comes into the justice's sights. Perhaps nowhere is this deviation more evident than in federal environmental law, much of which is uniquely dependent upon an expansive interpretation of the Commerce Clause. And many environmental regulatory schemes seem to push even the limits of the court's New Deal Commerce Clause jurisprudence, to say nothing of the court's more recent precedents reining in the commerce power. And one of those schemes, which Professor Mergen will address, is the Endangered Species Act, or ESA. Justice Thomas gave a shout out to then DC Circuit Judge John Roberts' 2003 opinion dissenting from denial of rehearing en banc. Then Judge Roberts wrote, "The panel's approach in this case leads to the result that regulating the taking, which is a term of art under the ESA, of a hapless toad that for reasons of its own lives its entire life in California constitutes regulating commerce among the several states." Oh, those were heady days. We property rights litigators had high hopes 2 decades ago of reining in the ESA, which protects dozens, if not hundreds, of species that live out their precarious but protected lives in but a single state. But even the Trump administration's Department of Justice defended the onerous application of the ESA to protect the bone cave harvest man, a blind bug that lives only in the Texas Hill Country, as a proper application of Congress's power to regulate commerce among the several states. Noel Francisco and Jeff Wall, call your office. Justice Thomas did not mention the Clean Air Act, but perhaps General Kuhn will tell us how the EPA's recent interpretation of that statute transgresses, if not the limits of the Commerce Clause, at least the limits of the cooperative federalism on which that act is assertedly premised. That seems like a good time to turn it over to my fellow panelists.
Good afternoon. I'm Andy Mergen. And as explained, I'm a former DOJ lawyer where it was my great privilege to defend the constitutionality of the Endangered Species Act and a number of challenges. Thanks for having me. It's great to see my former ENRD colleagues and meet General Kuhn. Maybe the best thing for me to do is just frame up a little bit about what the Endangered Species Act does. I mean, this is a piece of legislation that is now slightly older than 50 years old, having been signed by President Nixon in December of 1973. And, you know, for our purposes, there are four sections that I think are especially important. The first, we can just get out of the way right away, is what I think everyone thinks about when they think about the Endangered Species Act, which is the Section 9 prohibition on take of endangered species, right? This is what prevents you from killing an endangered species. This is what, you know, gives rise to, I think, the sort of man on the street understanding of what the act does. Of course, take is broader than just to kill, as it was interpreted in the Supreme Court's decision, in part in Sweet Home. So Section 9 gives us sort of like what we all understand the ESA to be doing, which is to prevent the take, the killing, the destruction of habitat of these endangered species. Section 4 is the process by which animals get on the list, right? And there's a fairly rigorous process laid out by Congress, a 5-factor test, a factor that incorporates some, I think, important Federalist principles in that you can't list the species until you look at the adequacy of other regimes, legal regimes that might be in place to protect the species. And in so doing, the agencies that are responsible for the Endangered Species Act, Fish and Wildlife Service and the NOAA, National Marine Fisheries Service, frequently look to what the states have been doing in that place. Section 7, I think, is not the part of the act that the man on the street thinks about in terms of the ESA, but it's a part of the ESA that is turned out to be profoundly important, and that's the consultation provision. When you need federal approval to take an action, you have to ask whether that action will jeopardize the continued existence of the species or adversely modify its critical habitat. And so what that means in practice, I think you're all, most of you are pretty aware, is that if you need, for instance, a permit from the Corps of Engineers or EPA, Section 7 would kick in at that point, and there's a fairly extensive process that can range from just a quick look to sort of see if there are any species implicated to a process that would authorize the take of some of these animals and put in steps to mitigate the harm to the creatures overall. And then finally, also relevant is Section 10, which is a permitting process by which landowners, states, et cetera, can obtain coverage. And over time, the agencies have repeatedly, I think, tried to make that process easier, less bureaucratic, to open it up to land development, et cetera, et cetera. The biggest challenge, as Eric indicated, to the Endangered Species Act has been this notion of intrastate species, right? Maybe 68% of all listed species, let's call it over 60%, live solely in one state. And the question becomes, where is the constitutional authority to regulate the take of those species? Well, if those species are on federal land, then it becomes easier, right? You can fall back on property clause authority. But what about the species living only in one state, inhabiting private land? Where does that authority come from? And that, I think, is what conservatives have been attempting to get before the courts, before the Supreme Court, for a very long time. And those attempts have been rejected twice in the DC Circuit, twice in the Ninth Circuit, at least twice in the Fifth Circuit, and the Fourth Circuit, the 10th Circuit, and the 11th Circuit, by a variety of jurists, including many conservative jurists like Ed Carnes in the 11th Circuit, Jay Wilkinson on the Fourth Circuit, Judge Holmes on the 10th Circuit, Karen LaCraft Henderson here in the DC Circuit. So it's not an issue that has found a very hospitable resting space in the federal courts. In fact, it's been rejected. And in every one of these cases, a cert petition has followed and been turned down. Most recently during the Trump administration in the 10th Circuit case involving the Utah prairie dog, the Petco case. So why have the courts found the statute constitutional? Well, if we go back to our Commerce Clause jurisprudence and the cases like Lopez and Morrison, which I think are rightly conceived as some sort of reset, we know that the Commerce Clause covers channels of commerce, instrumentalities of commerce, things in commerce, and activities that substantially affect interstate commerce. And the courts of appeals that have upheld the constitutionality of the ESA have relied on this third prong, and especially this third prong as it has been further defined in the Raich case, the marijuana case, the Controlled Substances Act case, where the court said, leaning back on far older authorities that sort of said like, where you have a comprehensive regulatory regime that has a substantial relation to commerce, that regime, even if there are some applications that have no relation to commerce, that aggregation is constitutional. And the courts have consistently found that the ESA is precisely this comprehensive regulatory regime. And I would refer you to especially Judge Wilkinson's opinion in the Gibbs case and Judge Karn's decision in the Alabama Sturgeon as being very robust discussions of this comprehensive regime. And so going back to Corinne's remark, and I think this is a point that we're going to discuss later on this afternoon, whether the agencies are adhering to constitutional boundaries. I think where you start with the ESA, has Congress adhered to the constitutional boundaries? And I think the explications offered in those opinions is that it clearly has, right? The act is a biodiversity statute. It is focused on genetic material. When Congress enacted it and President Nixon signed it in 1973, they understood that commerce, economic activity was going to be implicated. I mean, the statute specifically refers to the threats posed by trade, overutilization, habitat loss. These are all economic activities that affect these species. And, we can talk more about this as the afternoon progresses, but it is important to note that for the pharmaceutical business, for trade in some of these species, there have been important commerce connections, right? Something like 8 of 10 of the most commonly used medications find their origins in plants. And in 1973, Congress understood the value of this genetic material, the value that this genetic material might have in the future. So I think I'll stop there. I would sort of say that I think the ESA is just really interesting as an issue that the criticism is that it's a land use statute. And I think that Judge Wilkinson really takes that head on in the Gibbs case, and he says, properly understood, the statute is very narrow in application. It is focused on a set of wildlife, of creatures that are, at a precipice. It is not interfering with the traditional role that states have in regulating their resident wildlife. If we look at wildlife issues in general, those are issues of state concern. But for a very long time, Congress has involved itself in the preservation of species, going back to the Lacey Act, the Migratory Bird Treaty Act, and the role of Congress in the relation to these species is without federal action, they would have no protection because of the way they're threatened. And that the goal is ultimately, and this is really important, to hand over the management of these species to the states. So I think Judge Wilkinson has that exactly right. And I would finally say that I think this is an issue that, unlike some other issues in the environmental space, I don't think that conservatives are a monolith on these issues. We see that reflected in the jurists that have upheld the act. In the Mifepristone case, I was very surprised to see that Students for Life had filed a brief arguing that FDA's conduct violated Section 7 of the Endangered Species Act. And you know, I was surprised. But their argument is one that environmentalists themselves have made, that there should be a more robust Section 7 process for pharmaceuticals and the licensing of pharmaceuticals. So this is an issue that I think is not easily described as a left-right issue, and I'll stop there.
Perfect. Well, I will jump in there. Thank you to the Federalist Society for having me here to talk about something that's taking an increasingly large part of my docket in the Kentucky Attorney General's office. For reference, I've been in the office for 5 years, and for the first 4 years of that time, I had almost no federal environmental docket. That was just not something that came across my desk on a regular basis, and that changed for reasons that we can discuss last year. And you know, at present, I would say there's not a day that goes by that I'm not to make a water-based joke, but over my head in environmental matters on a day-to-day basis, practicing law in Frankfort, Kentucky. So to kind of give you an idea of everything that's coming across my desk now, and why I think the volume of rulemakings that started last year and that I think are going to lead up to the election this year, I think we're coming to a really important time to talk about whether expansive assertions of authority under some of these environmental statutes do in fact have a constitutional backstop, and how robust or not that backstop is. So to kind of give you an example about what my last year has looked like, we have been involved in suing both pre and post Sacket on the WOTUS and the amended WOTUS rule. We dealt with last year the disapproval of our state implementation plan under the Good Neighbor provision, which I'll come back to. We've dealt with the follow-on imposition of a federal state implementation plan, a federal implementation plan under the Clean Air Act. We're dealing with reduced NAAQS for particulate matter that are affecting our industry. There's a new methane rule that's just dropped that would require one of our agencies to hire over 100 new employees just to implement this one new rule. And that's just the beginning of it. There are rumors of other rulemakings that are on the horizon. The publication for the new tailpipe emission rule for model years 2027 to 2032 is expected in the Federal Register soon. What some are calling the Clean Power Plan 2.0 rule is coming. The MATS rule is coming. It's all coming, and I never had an environmental practice before the beginning of last year. And so I think all of that points to a lot of questions, some related to politics, some related to law. But I think the interesting question for today's panel is that each of these assertions of federal power that I've seen the last year occur under a statute, the Clean Water Act or the Clean Air Act, that generally speaking operates as a cooperative federalism statute. That's what the case law calls it, and that the case law comes back to the cooperative federalism approach of both of those statutes again and again. What does that mean? I think it means that the statutes envision separate but meaningful roles both for the federal government and for the state that I represent. A common theme, I think, though, of all of these rulemakings that we've seen is that we've seen expansive assertions of federal authority that, in my view, all seem to come at the expense of the states. My submission, I think, to you today is not that all of these statutes are unconstitutional. I think that we can work through some potential constitutional issues, but the problem, I think, is that the cooperative federalism approach at the heart of both the Clean Air Act and the Clean Water Act is, in my view, what helps to keep those statutes in their constitutional lanes. The question, I think, becomes, because of these expansive assertions of federal authority, whether those assertions, which discard the federal-state framework, run up against things like the Commerce Clause that's already been mentioned, as well as the Spending Clause in the wake of the NFIB case. So where I fit in the introductions here is Eric gave a description of the Clean Water Act, Andy talked about the Endangered Species Act, and they left to me to discuss a statute that's, if anything, more difficult than both of those, the Clean Air Act. And so any errors in discussing that are entirely mine, because as I said, I've only been doing this for a little over a year. So the Clean Air Act, it's cooperative federalism statute. It creates separate roles for the states and the federal government. So here's how it works at a very basic level. EPA sets the NAAQS, or the air quality standards, and then states decide how to implement those standards within their borders. We do this by creating what are called State Implementation Plan, or SIPs, in environmental speak. EPA then reviews our SIPs on the back end. So we get to decide how, in the first instance, we, the states, get to decide how to meet air quality standards. Only if the EPA says that a SIP is deficient does the EPA get authority under the Clean Air Act to regulate. If a SIP is found to be deficient, statutorily, EPA can come in with top-down regulation and pose what's known as a federal implementation plan, a FIP. So we have SIPs for states, FIP for the federal government. EPA has about 2 years under the statute, or 2 years under the statute, to impose a FIP, which gives time for the state to craft an approvable SIP. So at every stage of the process after setting the NAAQS, it is a cooperative federalism framework in which, in the main, the states are to play the primary role, the primary driver of meeting air standards within their borders. And I think this makes a lot of sense. We, the states, of course, have the general police power. The federal government doesn't. We are closer to our people. We understand that the air quality problems that affect Kentucky are thankfully not as bad as the air quality problems that affect California. And so it makes sense that the states get to be the primary driver subject to back-end review by EPA. So what's the problem? So against this backdrop of cooperative federalism, consider what has happened recently. So this is what I'm about to describe as a big fight brewing about the Clean Air Act. And hopefully, by talking about it, I can tease out some of the federalism implications, and then we can go from there. So early last year, EPA disapproved, essentially en masse, roughly 24 state implementation plans from states all over the map, all over the country. And they did so because the states allegedly did not comply with the good neighbor part of the Clean Air Act. And the good neighbor provision, simply put, it requires upwind states to account for the effects of their air pollution on downwind states, hence the name good neighbor, right? So they disapproved roughly 24 SIPs, and so they had 2 years to impose a FIP, in which time that states could craft approvable SIPs if they wanted to. But instead of waiting for that process to play out, the EPA acted almost immediately before the SIPs were final. When the federal government acts this quickly, generally speaking, you know something is up, and something was up there. And so we got a FIP imposed on us immediately before we could really even digest that our SIP had been disapproved. And that prompted a flood of litigation. And part of that is pending at the U.S. Supreme Court, the Ohio case, with a decision expected by June. I'm not here to talk about that. I want to talk a little bit more about the SIP part of it because I think it's more relevant to the federalism implications. And to do that, let me give you 2 minutes of talking about what happened to Kentucky, and then we can go back and have more of a panel discussion. So in Kentucky, we submitted our SIP in January of 2019. So over 5 years ago, we spent a lot of time doing so, and we relied on a data set that EPA gave us to craft our SIP. And everybody's going to go to sleep now while I start to talk about a data set under the Clean Air Act, but I promise it really is that simple. Everything is key to our data set. To understand the implications of downwind air pollution, you have to have a data set. That's how you tease it out. And we used what EPA gave us. And so when our SIP was disapproved several years later, EPA said, oh, well, you didn't use the right data set. Here's the data set you should have used. And by the way, this data set wasn't available to you by the statutory deadline of your SIP. In fact, it wasn't available to us by our statutory deadline to act. And because there's this new data set, we're going to disapprove your SIP and then immediately impose a FIP on us. And so one of my sister states has used this great analogy of a law student taking a law school exam on an unsettled issue of law. You write a great law school exam analyzing the law, you submit it to your professor, and then the Supreme Court the next day decides the defining issue in the area, and the professor fails you for not discussing the decision that came after your law school exam was submitted. And so that's effectively what has happened not only to Kentucky, but to a dozen or more other sovereign states. We were dinged for not considering data that did not exist. And that denial, which we think was arbitrary and capricious, we're litigating that. That denial is the gateway for Kentucky or for EPA to impose top-down regulation on Kentucky. And obviously you can see the cooperative federalism implications of that. We never really got a serious chance to grapple with the data that the agency says is the one that matters. All of this points to why this topic is so important. The cooperative federalism approach of the Clean Air Act, of the Clean Water Act, protects against incursions on the state's sovereign prerogative with respect to our natural resources, our air, our water. It's the states, after all, that possess a general and plenary police power to regulate and protect our health and safety. And I think that's where Justice Thomas's opinion comes in. That's why it's so important. We're seeing unprecedented assertion after unprecedented assertion of federal power from EPA. And at what point does the cooperative federalism approach not protect against that, such that the Constitution has to provide the backstop? I don't think we'd be having this conversation here had we not seen all of these unprecedented assertions of power. So that's where I'll leave it.
Thank you all. So before I ask any questions, do any of you want to respond to what any of the other panelists said? Eric, do you want to start?
I would, thank you. Professor Mergen said a couple times that he thinks the ESA's application is narrow. And to be fair, that's a word that certainly in part is in the eye of the beholder. I guess as I beheld it, filing about 800 merits briefs in the courts of appeals in over 4 years, that wasn't my experience. And I guess the first point is about Section 7 that Professor Mergen discussed. If you get a permit from any other federal agency, the Department of Interior, the Fish and Wildlife Service, is almost always going to be involved as well. So think of all the trouble the Sacketts had with EPA and the Corps of Engineers. If the Sacketts went the permit route, they'd almost certainly have another hurdle with the Fish and Wildlife Service as well. So that, I think, militates against narrowness. Another thing that I observed is the theory of the ESA is to bring these species under the Act's protection, do the right thing, preserve them, conserve them, get them on their feet, so to speak. But like an addict, they never go off the list. Not never, never, but almost never. And so I think that vision of what could have narrowed the statute hasn't played out in practice. And then I guess another thing that struck me is a species can be endangered in so many places at once. You think endangered means it's a small population, but there can be a small population in California and a small population in Nevada and a small population other places. They're called distinct population segments, if I remember correctly. And so that's another aspect in which it's not narrow. And finally, I guess, if the Clean Air Act at least has the rhetoric of cooperative federalism, I don't recall hearing that, seeing that in the ESA context. I don't think there's even that window dressing.
Okay. I'm out of practice of sparring with him, so you'll have to forgive me, but we did have this relationship for several years when he was at the Department of Justice. So I guess I would say, like, in the 800, whatever, I don't think that was 800 ESA cases, right?
True,
Okay.
true.
All right, so if you think about the subset of ESA cases you saw, probably the majority at DOJ, right? The big criticism, I think, on the right of the ESA is that it's a land use statute masquerading as a narrow environmental statute. And I guess I would say if you cast your mind back to how many of those cases actually involved people in the Sackett's position, I would say that's a very small number. Because many of the cases that we litigated at DOJ involve very clearly sort of federal interest, whether that's, you know, the case that many of us are, you know, hear a lot about, which is the Atlantic right whale, which is imperiled by fishing operations. But these are fishing operations that are federally regulated. These are animals that are occurring in federal waters. The Commerce Clause issue that is implicated for the landowner with a single toad on his property is not implicated by that, nor is it implicated by the debates over the spotted owl that occurred all of those years ago. So I think that, to my mind, there's a sort of mythology about the act and how far it goes and how it regulates sort of ordinary liberty-seeking Americans. I think that doesn't actually happen very often. And I will also say it's going to happen a lot less following Sacket, right? I think the assessment by most folks now is that the universe of waters of the United States has been significantly reduced by this statute, and by the court's decision in Sacket. In some states, like New Mexico, tremendously, and in other states maybe less so. But a lot of times where the ESA comes up, it is in that Clean Water Act consultation, and that's really been reduced. So part of my pitch to you all today, and thank you for being so polite to me as the, you know, liberal here, is that you can put this way down on your to-do list, because we don't know at all whether the ESA is really going to, in the post-Sacket world, really implicate the traditional criticisms of the act that have persisted previously. As to the cooperative federalism thing, I can't do better than Judge Wilkinson's decision in Babbitt, right? There are many places where states are mentioned in the act, including in the discussion on the listing in terms of whether the existing regulatory regimes are sufficient to protect the animals. There are issues related to other issues related to listing with regard to states, and the imposition on the states in terms of what I would consider the part of their federalism that relates to wildlife is incredibly modest. We all know that if you're going to go fishing in Kentucky, you get a license from the state. If you're going to go hunting in Kentucky, you get a license from the state. So in the universe of sort of wildlife issues, the ESA takes up a very small space. And I think it's profoundly important. I think the public supports this. I think that there's a reason that Congress was pretty dramatic in its language. I think that there's a reason that twice C.J. Berger did not raise any questions about the constitutionality of the statute. The first time in Capert in 1976 involving the Devil's Hole pupfish, and the second time in TVA versus Hill, where his gloss on the statute really, defined the statute in the way that it is defined today. When I feel sad about the rhetoric about the ESA, I go back and I read the brief that was filed by the United States in Capert. This is a case involving pumping by a farmer, very much an economic activity, that put the Devil's Hole pupfish, imperiled it in this part of Death Valley National Park. And the brief there it was written by a young lawyer in the Solicitor General's office, Ray Randolph, and the Solicitor General I'm the oldest person on this panel, maybe, I can't remember how we stack up, but the Solicitor General was Bork. And if you read that brief, it is a full-throated defense of the ESA, and I think there's a reason that they were comfortable making that full-throated defense. And if I just say one thing about the Clean Air Act, it is undoubtedly, as a Justice Department lawyer, I always talked about the cooperative federalism of the statute, and the same for the Clean Water Act. And I think that what we need to keep in mind is the downwind states are also part of our federalism, right? And so it wasn't just in the Supreme Court last February, the Solicitor General defending the scheme. It was also the Solicitor General's office from the state of New York. And you know, geography is a funny thing. And so for some things like the Clean Air Act, you know, the industrial Northeast may be more burdened. But here's the thing. All of these things, everybody is burdened differently at one time or another, and that's all part of our federalism. And the final thing I'll note is that all of this seems to me, when you describe the Good Neighbor Act litigation, this is not constitutional litigation. It is arbitrary and capricious APA, ANC litigation. The question is whether it was fair, as you set forth, for them to like change the rules you know, midstream, right? That's an ANC case. That is not a constitutional dilemma. That is a, I'm gonna sue you because your decision is arbitrary and capricious. And I think that sort of illustrates the fact that I think the constitutional concerns here are not as heightened as Justice Thomas might suspect. But I'll stop, sorry.
Yeah, so I'll add to that final point. It's well taken, right? I'm suing about the SIP disapproval, and I have not invoked the Commerce Clause in my petition for review and briefing since then. I guess my point was more of a modest one, was that there are these structural protections in the Clean Air Act. There's similar structural protections in the Clean Water Act that protects state sovereign prerogative that I would submit keep the statutes within their constitutional lanes. And when those structural protections are not respected, when there's too much on the federal side and not enough or none on the state side, I do think that by taking such an aggressive reading of the statute, the EPA, I think, is walking into constitutional concerns that perhaps would not address but for that. And the step back point that I would make, just sort of in defense of the states, our position is not that our air and water should not be regulated. Like, we care about it a lot. We're very proud of our lakes in West Kentucky, our beautiful streams in the mountains of eastern Kentucky. We have an entire regulatory regime under state law that regulates, quote unquote, waters of the Commonwealth. We're a Commonwealth and proud of that. And we've got, you know, a whole division of our environment and energy and environment cabinet that regulates that does permitting under state law, that does landfill, any of that, all of that is regulated under state law, and we're quite proud of that and take it seriously because of what a beautiful state we are. The point is that we don't have the resources to do that because we're spending so much time under a spending clause statute doing the federal government's bidding with these expansive interpretations. The Clean Water Act, to give you an example, in WOTUS, the 2023 rule initially was based on Justice Kennedy's concurrence in Rapinos, the substantial nexus test that formed a big part of the 2023 rule. You know how many votes that Justice Kennedy's test got in Sacket? 0. It was an expansive test that the states couldn't understand, litigants couldn't understand, landowners couldn't understand, and it got 0 votes, yet that formed a significant part of the rule that was rushed out after Sacket had been argued at the U.S. Supreme Court and imposed on Kentucky. You know, no wonder we had to go to court and get a preliminary injunction like 26 other states did successfully. I guess my point is the constitutional problem is arising largely, at least under the Clean Air Act, potential problem is arising only because the cooperative federalism part of this is just being forgotten.
So I think that leads to the next question, which is, it sounds like we have 3 different views here, that it could either be that the statutes have constitutional issues, which I think, Eric, I'm hearing you say. the Solicitor General Kuhn, you're saying it's the implementation of the statutes, not the statutes themselves, that necessarily have the constitutional issues. And Professor Mergen, none of the above. No problem. Is that right?
I think that's right. I mean, obviously, interpretation and application of statutes by agencies and courts are critical in addition to the plain text of the statutes. We, at the Justice Department in the Trump administration, had to worry that our own clients were overreaching. So I guess I'm not surprised that Solicitor General Kuhn thinks that the Biden administration's agencies are overreaching. So that's clearly part of it. Just to go back to something Professor Mergen talked about, the Raich case, Gonzalez v. Raich from, I think, 2006, the substantially affect test. And while that's on the books, and it still is, probably the ESA fits under that test. So that's the dream to take out Raich. No more faint-hearted originalism.
So, Solicitor General Kuhn, do you think if the cooperative federalism aspects of these acts are properly policed, that the acts themselves are constitutional?
So I think the constitutional question is probably different for the Clean Water Act than the Clean Air Act. And I think a large part of Justice Thomas's opinion in Sacket was tracing how the terms navigable waters and waters of the United States sort of carried the old soil with them from these were statutes that were interpreted pre-New Deal Commerce Clause precedents. And the big case, as Eric noted, is the Daniel Ball. And Daniel Ball, interpreted the Clean Water Act's, the language that went into the Clean Water Act in a way that really focused on the channels of commerce and took sort of a very narrow view of what it meant to be navigable waters and waters of the United States. And so I think there's a lot of statutory history with respect to the Clean Water Act that limits its language in a way that it could not be problematic. And I think that Justice Thomas's mention of constitutional concerns was an aside to that larger point about how we should be interpreting the of the United States and navigable in the statutory definition. So I think that the constitutional issue, although it's lurking under the Clean Water Act, we do have constitutional claims though in our pending WOTUS litigation. So it's still there, and I think broad interpretations of the Clean Water Act run up against constitutional limits. It's different under the Clean Air Act, right? The sort of the history, statutory history that led to the geographic terms in the Clean Water Act. I'm not aware of any sort of similar history that would similarly constrain the interpretation of the terms under the Clean Air Act. You'll note that in Justice Thomas's opinion, he noted that other federal statutes contain much broader language than he would read the CWA to contain. And so I do think that the Clean Air Act is one of those statutes that has much broader language. And so some of the statutory narrowing arguments that would exist under the Clean Water Act may not exist under the Clean Air Act. So one of the things that I do think is interesting on the Clean Air Act that we haven't really talked about are, it's a spending clause statute. The states are, doing the federal government's bidding on CWA permitting or CAA permitting and such under a spending clause statute. The DC Circuit post NFIB has looked at this from a spending clause perspective and has upheld the Clean Air Act under NFIB, under Chief Justice Roberts' opinion there. That has not gone to the U.S. Supreme Court post NFIB. The D.C. Circuit's case on that, I think, was a 2015 one where was led by Mississippi and Texas, I believe. And so there's been some scholarship after the D.C. Circuit ruled that, in particular, Professor Adler talked how thinks the D.C. Circuit got that wrong, and that there may well be a spending clause problem with part of the penalty for states is losing out on your transportation funding. And transportation funding can obviously be a huge part of a state's budget. And whether that gets big enough to be a gun with the head, or a gun to the head, what Chief Justice Roberts called it in NFIB. So, I think the constitutional issues are out there, and to the extent the agency continues to push, I think that naturally they're going to arise and have to be litigated in some way.
Yeah, and so Professor Mergen, I have sort of the same question for you, but in reverse. Are there scenarios, hypothetical scenarios, you can see where the implementation would cause these constitutional issues, or will it always be those issues only arise if the agency is being arbitrary and capricious and going beyond its statutory authority?
Yeah, so first off, you guys can call me Andy. This professor thing is a new thing for me. So.
I'm pretty sure we called you that before you were a professor, so.
I think that, we have a constitutional avoidance canon for a reason, right? I don't think that, and this is part of where I come out on these issues. Like, I as a Justice Department attorney, and you guys knew me there, so you can disagree if you want, but I felt, first and foremost, I was an institutionalist and a small c conservative, right? I understood that the Justice Department acts as a conservative actor. I have spent a lot of my career making my friends in the environmental community very angry with various doctrines like standing and threshold justiciability issues, which I feel like should be fairly applied to all sides, right? I feel like they play an important role in our constitutional system, and the courts should adhere to those principles. I would say that, yeah, most of the time I think that these are really APA issues. And to give you an example, these issues regarding SIPs and FIPs and the Clean Air Act and the Good Neighbor Rule have been around for decades, right? And so in terms of sort of like we talk about, history definitely matters to the courts on several scales, right? And one thing we look at when we consider like doctrines like major questions or whatever is regulatory antecedents. And I would submit to you, Solicitor General Kuhn, that what the agency has been doing here is not a significant departure in any way from what it's been doing for a long time. And that, to me, is an arbitrary and capricious issue. What has changed is a court that's pretty conservative and a sort of a notion that this is the time to act, right? We see more stuff, more emergency stay motions, all of those sorts of things, seeking an advantage from a court that seems less restrained. On some of these threshold issues that I spent my time in the government defending. So I do sort of think that, I'm not saying that constitutional issues never come up or that agencies don't cross the line. I mean, I think importantly, right, one area where we see this come up is when an agency says no to somebody and the Fifth Amendment takings clause or just compensation clause is implicated. And that is implicated by agency action, right? It has nothing to do with sort of them stepping outside of the bounds of the statute. It has them having taken an action that may require just compensation. But by and large, I think the agencies are not, in these cases, are not on the outer limits of the Constitution. I think what's really interesting about the Clean Water Act, I have a lot to say there, and there's not enough time, you can imagine. But I don't think Congress clearly in 1972 was extending the definitions of the reach of the statute beyond traditional notions of Daniel Ball navigability, as it must. And I think if you step back and you sort of say, like, I'm interested in what is happening in environmental law in this moment, I would look to what's happening in states like Idaho, Nevada, Montana with regard to groundwater. The federal government plays a huge role in water quality, right? Clean Water Act is a water quality statute. The states have always had primacy, in the West especially, on water quantity issues. And they are having to become creative and ambitious in changes in their legal regimes to deal with groundwater pumping. And these are not like the Commonwealth of Massachusetts, where I spent a lot of my time. This is Idaho having to sort of be creative. And they're running up against the same issues the federal government that comes up. You've gone too far, et cetera, et cetera. But I think what we do see is that what those states are doing is responding to the connectedness of these water regimes. And what we have lost in this decision in Sacket is sort of the science behind all of this, which is really, really important. And I think as we talk about Justice, this is my last point, sorry. As we talk about Justice Thomas's concurrence, we should recollect that it is a concurrence, right? It is not the majority opinion. He did not write the majority opinion. And I think I have lots of problems with the majority opinion, but I do think it's telling that the concurrence was not the majority. And I'll stop there.
Yeah, so your point is really good about the connectedness of all of these resources, right? And I think what we have seen more and more is that the science is not going to draw clear lines for us. In some sense, the air, the water, the entire ecosystem and all the species in it are going to be connected. At the same time, these statutes obviously contemplate a place for the states. As you said, you know, the fishing, the hunting, the groundwater, so many of these issues we leave to states. There are state waters, there's state land, there are species that are separately protected under state law. So where, and I'd pose this to all of you, where do we think that line drawing happens then in the regulations that try and implement these statutes?
My perspective on the science is in one sense, I don't disagree with you. I think everybody recognizes interconnectedness. Everybody recognizes effects. But those, that's not, and I don't even think that's a 21st century insight. I don't think the framers were so unsophisticated that they couldn't understand interconnectedness. That's the purpose of the national union, is because the 13 states were interconnected, and that's why Congress has its express powers in Article 1, Section 8 to deal with precisely those things as to which that generation understood that was connected. So the science, I think progressives always want science to give us the answers so we won't argue with each other. So there won't be politics anymore. There won't be the messiness of democratic give and take. And science can give us the information, but can't solve the hard problems that resources are finite, and that you can't, everybody can't have everything that he wants. We know this in Northern California, where I live, with the water. Not everybody can have all the water. There's just not enough to satisfy all the needs for the species, for homeowners, for agriculture, and I'm sure there are other things. But the science doesn't preclude politics, doesn't preclude the hard decisions.
Well, as a progressive, I'm going to defend science. I think, I mean, for sure, right, there are hard issues, and your point about the finite resources issue is an important one. But I think that the reality is that we know we can do better than we are in terms of incorporating, understanding that these issues are, that, you know, things like wetlands, the science, I do think that there has been a shift. I think that you see that in legislation. There was an act called the Swamp Busters Act, right? And the science has changed around all of that, right? We understand that wetlands play critical, you know, provide, I'm going to use a liberal term like ecosystem services. What it just means is that it is beneficial to have wetlands around for filtration, to take the brunt of large storms. All of that matters. And when we construe the law in a way that I think is excessively narrow as a constitutional matter to lose the benefits of those interconnected systems, we're making a real mistake. And I just want to change topics for one point that I wanted to make earlier, which is that, I think that as I talk about the ESA, it's really important that we understand that we're not at the same place we were 20 years ago with the ESA. Things are changing. I mean, Democratic administrations have often understood that the statute requires some buy-in and that they are working hard on sort of these permitting issues. And one example is a technological answer, which is that the service now has this IPAC system entirely intended to streamline permitting, right? And this program has gotten rave reviews in general. And I think it's just the start of the kinds of things that we can do to deploy technologies to make better decisions in this space. So I think we need to slow down on the litigation and sort of ask ourselves, I mean, I litigated the Department of Justice for 33 years. Like Eric, I've seen a lot of lawsuits. And I still feel the learned hand thing, dread, right? Like there's gotta be a better way. I know that we're litigators, so it's fun. It's fun to write briefs. The advocacy is fun, but there's gotta be a better way. And that's why I think we can sort of slow down on the notion that all of these, that the only way to take the pressure off is through litigation, because I think there are other mechanisms available to us. And I think that when I am around my colleagues in the university who are not lawyers, they have very sophisticated ways of understanding like what is important in the natural system and what is less important. And obviously, to your point, Eric, there are trade-offs. I mean, progressives understand this in relation to renewable energy, right? You have to put solar somewhere, you have to put wind somewhere, right? And there are good ways to make those decisions, and I'm not sure that litigation facilitates that process. I'll stop there.
Tell your colleagues they're going to have to dig lithium out of the ground. A lot of lithium, a lot of copper.
Let me make 2 points. On the science point, I'm no progressive, but I also defend the science. I'll just say that the federal government doesn't have a monopoly on it. We care about the science in Kentucky too. We've got a whole cabinet that's devoted to it with career public servants that care as much about, maybe more about our natural resources in Kentucky that are unique and something we're proud of. And so the notion that I think part of the mistake of the EPA's approach is that they think they've got a monopoly on it, and they certainly don't. The second point is just to defend some of the lawsuits that I've filed. So state-led lawsuits in the context of at least the Clean Air Act, this is nothing new. Like, I would agree with you that state-led lawsuits have exploded in recent years, that we're seeing more than we've ever seen before. But in the Clean Air Act space, if you go look at the DC Circuit docket, for all of the 2000s, there are pick state versus EPA that have been filing lawsuits against the EPA. And why that makes sense, because we're regulated under the Clean Air Act, under the Clean Water Act, as states, qua states. And so, Andy was talking about all these state standing doctrines. State standing's not an issue in these cases, right? We are the object of the regulation. We have self-evident standing. And so there is a long history of states stepping up when we think our sovereign prerogative has been invaded. I think look at the early Clean Air Act cases in the 1970s when the EPA was taking the position, this was before New York and Prince, where they said that they could conscript states to do whatever they said. There were lawsuits filed, and the Ninth Circuit struck down that part of it, the DC Circuit struck down that part of it. And so these were all state-led efforts. This was 60 years ago, and we had states suing on this. So I do think that the criticism of too many state lawsuits, you can levy that about a lot of things. But I think in the context of the Clean Air Act, especially given the cooperative federalism framework, I just don't think that criticism lands there, because if not the states, then who?
So I want to follow up on this point, but after that, I'd like to open it up to questions. So if anyone has one, if you could start lining up at the microphones. So we have seen, now routinely in environmental law, states lining up on either side, right? When any environmental law regulation comes out, you're going to have a coalition who comes out against it and a coalition who comes out in support of it. And they're playing two different theoretical roles there, right? You have some states that are saying there are versions of a downwind effect on my state. There are harms where I need a more stringent federal regulation to protect my interests. But then you also have the flip side, which is states saying you are infringing on my sovereign rights, you are over-regulating me. What do the three of you see as the proper role for states on either of those sides in litigation? And is this more broadly a good or a bad thing that we now always have states involved in these challenges?
I'll speak. I think that it's good for courts to hear from states that have diverse perspectives. I was involved in a case in the Sixth Circuit recently outside the environmental space, but 43 states weighed in through amicus briefs or as parties. I think that's a good thing, regardless of whether a lot of those states happen to disagree with me. But I think that courts should hear from the states. The particulate matter issue that I mentioned at the beginning, I think there were 25 states that sued to challenge it, and 15 or so have intervened alongside EPA. So we're going to see 40 of 50 states taking a position in the D.C. Circuit. I think that is unequivocally a good thing, because the states, we have unique injuries, we have unique perspectives, we're closer to our people than the federal government is, and I think that the more of that we see, the better. So even when other states come in and disagree with me, I think it's great. My SIP oral argument in the Sixth Circuit, it's going to be me, the federal government, and the New York Attorney General. I didn't think the New York Attorney General should get time at the podium, but I think, again, to the point, the more the merrier, I guess.
I'm not going to disagree that there's a role for states in this litigation, and I certainly agree that states have been involved in Clean Air Act litigation for a really long time. I guess what I think is regrettable is how partisan this litigation has become. I mean, I've practiced law for over 30 years, so I can remember a time, and most of that time as an appellate attorney, working with, the National Association of Attorney Generals. And, at that point, that organization I felt was states had different views and different politics, but it seemed far less partisan than it does today. And I think the partisanship results in amping up the rhetoric in a way that is unhelpful. And if for every jurisdiction that I have been in, I don't know if you've ever had this experience, but I've wondered, why is my Attorney General doing X or Y when I know there are problems here? Why is my Attorney General in Amarillo today when there are problems here? Or usually the SG, sorry, not the AG. When there are problems here? Or why is my SG in the Northern District of California, or the Southern District of New York, when there are problems here? And so my point is, I don't disagree with the Solicitor General at all that there's a role for states in this litigation. I guess I just feel like it has become a highly partisan endeavor, and that amps up the rhetoric in a way that I think is unhelpful. And the one other thing I'll just say is that there have been interesting studies about the federal government in the environmental space. And what those studies show is that there is a ton, like agencies like the Corps of Engineers take into account regional differences, regional concerns in their permitting decisions. So this notion that states are ruled by the federal government, like Rome, far away, and I do think about Rome every day for people who track that meme.
You're one of us.
Yeah. That the federal government's Rome and doesn't really understand what's going on in Kentucky. And yet, a prof out in California, Dave Owen, did a study on regional administration. And his point is, the Corps of Engineers is responsive to the local community. It's unfair to sort of suggest that these bureaucrats are all off doing their own thing.
All right, we'll take a question in the front. Would you just say your name and who you're with?
Sure. I'm Stephen Taft, a recent graduate of Richmond Law. So thinking back to my con law classes when I learned this, it was often alongside cases on other subjects that are Commerce Clause that people don't know who aren't lawyers, like Katzenbach and Heart of Atlanta Motel. And that immediately comes to mind for this reason. The way I interpreted the Rapana's concurrence of Kennedy was really an implicit, subtle warning that if you take down this issue, if you take a sledgehammer to environmental Commerce Clause case law, other matters that we care even more about, such as civil rights, come under question. Now, I want to ask all of you, do you think there's a legitimacy to those concerns, and can they be allayed by those who would walk back, like Thomas would, to an earlier interpretation of the Commerce Clause?
I mean, I'll just observe that your point about Katzenbach and Heart of Atlanta Motel, those cases are also discussed in the Gibbs case by Judge Wilkinson, by Judge Carnes in the Alabama Sturgeon case, and both those judges are making exactly the same point about the accommodation cases.
There's a spectrum of views about stare decisis, and I'm with Justice Thomas, and that's get it right. And I think he's suggested cases, what's Calder versus Bull, I think is 1798. So he's willing to go back pretty far. And again, I'm sympathetic with that view. Get it right, even if it tosses out some more recent doctrine.
I guess my point would be that I think the agency actions are sort of at the outer bounds of the Commerce Clause authority. And, to say that, regulating a hapless toad, to quote the Chief Justice in California, to say that you can't do that is not going to call into question, especially under sort of stare decisis principles, sort of some of those key precedents. I do think that, the agency's claim to authority rests on cases like Wickard versus Filborn and Darby, and that's what Justice Thomas said. But, I do think that sort of to the extent there are problems, I think my position has been that there are problems out only on the edges of the agency's exercise of authority. So I don't think we're going to see cascading effects, even if you can get 4 justices that would agree with Justice Thomas.
Yeah, and I would tend to agree. If you think about it, environmental law and the cases involving it tend to be where we see expansions in a lot of these doctrines, which I think are designed to accommodate some of the unique issues in environmental law and how you fit them into court. And I think that's why so many of the seminal decisions that you see, right, like Lujan, Chevron, Bennett v. Speer, Mass v. EPA, West Virginia v. EPA, these are all environmental law cases that then have broadening effects on other areas of law rather than kind of in reverse.
Thank you.
I mean, I would say that if you look at Ginsburg's concurrence in the Rancho Viejo case, which is the Arroyo Toad case, he's slicing the salami pretty thin, because he concurs in the decision, right? And the decision says that the ESA is constitutional in this application, right? Rancho Viejo is a large real estate concern, clearly commerce implicated there. What Ginsburg says in his concurrence is, I just want to be clear that I have some doubts as to whether it would reach the guy like hiking along on his own private property who squashes an Arroyo toad or something like that. And when then Judge Roberts, now Chief Justice Roberts, writes his concurrence from the denial of cert in Rancho Viejo, he's sort of saying like, I think we should at least consider like these issues. He's not saying I'm going to rule in favor of John Eastman in Rancho Viejo. He's saying like we should think this through, and if that's the limit, if Ginsburg gets the case where the guy squashes a toad on his own property and no commerce is implicated, that probably doesn't get at the accommodation cases, but that's a pretty thin victory for folks who are concerned about the reach of the statute.
And I'll just say this is a great example of when we were at DOJ and you were tempted to ever go on Westlaw. The answer was to walk down the hall first and just pose the question to Andy and get an answer like that.
I do think it was a dissent from the denial of rehearing in bank. But
It was a dissent, yeah.
Okay.
Okay. Oh.
In the back.
My name is Bonnie Wachtel. I'm in the investment business. I'm just going to amp up the rhetoric slightly. And this is addressed to our gentleman identified as a progressive who's so kind to join us here at the Federalist Society. I was really struck by, in your comments about the Endangered Species Act, when you said you can put this way down on the list to be concerned about. And that's good, because there is so much else on the list to be concerned about. From what if we look at environmental laws also encompassing all of the climate change considerations, you know, in banking regulation, we have efforts to ration capital away from fossil fuel and towards renewables. And just coming out of in the SEC context, the climate disclosure rules, I'm told, are going to cost more than all the other disclosure rules put together. And from EPA, we have the new CAFE standards that are trying to put internal combustion engines out of business, although there is an excellent scientific argument that overall EVs are not better for the environment than ICE. And of course, we have the Clean Power Plan, where the Supreme Court had to just throw up their hands and say, regardless of the law, you're just way over the limit, it's too much. So for you, as someone who's obviously a very thoughtful and well-regarded progressive, do you support all of these efforts that are going on in the legal zeitgeist, or do any of them give you pause?
Please go on the record, Andy. We're recording this.
Yeah. I mean, kind of, you know, you said I was kind to show up. That's one word for it. Maybe there are others too. I guess I feel like, having been around this space for a long time, I recognize that there's a lot of rhetoric on both sides, right? But I would define myself as a progressive. I'm not sure all of my friends would put me in that box, but some would. And I am astute enough to know that on the other side, sometimes, you know, the benefits of a regulatory action are very overstated, right? I spend my time defending rules that I thought sometimes were, in the Obama administration, very, very modest. And the rhetoric around those rules becomes sort of mind-blowing, right? On both sides, right? The defenders of the Obama rule say, this is a game-changing BLM rule. And on the other side, the oil and gas industry says, life as we know it will come to an end if this rule is enacted. And I guess my advice is, first off, for everything you said, I'm in favor. And I feel like the SEC scaled back their ambition. That's true of some of the car rules too. Like, notice and comment matters. Talking to industry, getting the pulse of what they think is doable and undoable really matters. And I think administrations are generally committed to that process. There's a lot of opportunity for people to come in. On the SEC rules, I think there's a lot going on in the EU that sort of lessens the effect of sort of what is going on for SEC. But I think the overall point I'd like to make is that I think everyone here is a thoughtful person, and we need to drill down on the rhetoric. Like, the New York Times isn't always right, and the Wall Street Journal isn't always right. And we have to take a hard look, because it's in the interest of lots of people to amp everything up.
I'll offer what I promise is a much more abstract question. So it may even be one of federal civil procedure, but I would like the panel's perspective on this. My name is Roger Hanshaw, by the way. I'm a lawyer in private practice in the state of West Virginia. In states in which state departments of environmental protection or environmental cabinets, or by whatever name we're known, exercise delegated authority on behalf of the federal government with respect to the various environmental statutes, I'm interested in your perspective on the strategy of advocacy organizations to bring suit against EPA for imposition of cases that are then resolved by consent agreement that result in imposition of, say, under the Clean Air Act, a finding of non-attainment, or under the Clean Water Act context, the imposition of a TMDL, outside the participation or involvement of the otherwise governing state entity in the federal courts.
In the Trump administration, we call that sue and settle. And we tried, I think, at least at EPA, to impose what I thought were a reasonable and was a reasonable and modest set of procedural safeguards that would enhance public participation. I think those are long gone by now with the new administration. But it's a problem. It's an issue. There is perhaps not an obvious single solution, but it is a problem that needs to be addressed and is problematic from a good government public participation standpoint.
Yeah, I would just say that, I mean, I think, you know, the program mentions transparency. That is an issue that everyone is interested in. My progressive friends, clearly the Federalist Society also. And, you know, I'm not sure precisely what sort of consent decrees you're talking about, but, you know, you can go on ENRD's website today and you can see tons and tons of consent decrees posted for comment, because the department has, in the main, I think very much promoted a full transparency of these sorts of settlements, right? And I think some are published in the Federal Register. Notice is published. They show up on ENRD's website, depending on the kind of lawsuit. And I would just agree with you that I think that sort of transparency is really, really important.
Okay, thank you.
Yeah, I'll say this is something that we looked into there, and part of the problem, I would say, is actually resource-based and statutory-driven. So you will have acts, for example, this comes up in the ESA, where there's a statutory deadline to take certain actions that the agencies just haven't taken, right? So in litigation,
State agencies.
oh no, this would be federal agencies.
Okay.
So you're talking about a scenario where there's a challenge against the state agencies and not federal?
I'm talking about the growing practice of advocacy organizations of achieving imposition of de facto state standards through settlements by the federal agency in light of the state's decision not to take that very same action.
So,
I'll give you a very specific example.
Like an
Let me just take it out of the abstract. Let me give you a very specific example. Pending now in the Southern District of West Virginia is such an arrangement in which the advocacy organization has sued EPA. The case has been resolved, or it's attempting to be resolved now, by imposition of a TMDL in a portion of the state of West Virginia for ionic strength and ionic pollution. The West Virginia Department of Environmental Protection has 3 times rejected appeals by advocacy organizations to impose that very standard. And now, if our intervention is denied, we have sought to intervene in the filed case to impose that standard. If our intervention is denied, we will now have had imposed in southern West Virginia a water quality standard that our Department of Environmental Protection, pursuant to our delegated authority under the CWA, has rejected. I'm just interested in your opinion on that.
I missed who you represent. Do you represent the state or someone else?
Well, I'm the Speaker of the House in the state of West Virginia.
I'm sorry I didn't know that.
There's no good reason you should, but I'm a lawyer. This is my practice.
Right.
It's what I do. It's what we all do. It's not an unusual practice. It just happens to be a very live scenario that I've.
But the state is in the litigation.
It is not.
It's not. They have not intervened or anything.
We have intervened, and we've not been granted. Our motion to intervene has not been granted. There's the point.
So let me give you a few things to look at. One of the things that happened between the changeover from the Trump administration to the Biden administration, of course, was a lot of regulatory changes, and there were a couple of attempts at sue and settle. The most prominent initially was in the context of the public charge rule, where the Supreme Court had granted certiorari, and then the Department of Justice, after certiorari had been granted under President Biden, agreed to dismiss an appeal such that a nationwide vacatur of the rule was there, and a lot of states tried to intervene. This happened a couple of times in the immigration context during COVID, and there was a really persuasive dissent out of the Ninth Circuit in an Arizona case that talked about the importance of being able to intervene to prevent sue and settle. It got to the Supreme Court, and they ultimately dismissed cert as improvidently granted because there were a lot of vehicle problems. But the Chief Justice Roberts, wrote a really persuasive opinion respecting the dig, I think is how he phrased it. But anyway, talked about the importance of issues like that being settled, about how sue and settle shouldn't happen, and that you shouldn't be able to circumvent the Administrative Procedure Act through that. So I think that you've got your finger on an issue that matters, and that we're seeing litigation about. The Supreme Court granted cert on it, actually. I mean, that was the term that they had 3 intervention cases, and so there's a growing body of law out there, and so I would take a look, especially at what the Chief Justice said in the context of that Arizona case.
Wonderful panel. Thank you very much.
Seems like you could hire the Solicitor General of Kentucky.
I love West Virginia, so happy to help.
They've got a pretty good one themselves. Well, if there are no further questions, are there any closing remarks from up here?
Always nice to spar with you, Mr. Mergen.
All right, well then please join me in thanking our panelists today.